This Choice One Bank versus L&M Family Investments. Change this for the record.
Good afternoon, Your Honor. John Tucker on behalf of the plaintiff, Choice One Bank.
I'm Michael Dalton. And Your Honor, I'd like the court to take some judicial notice with the complaint we have. We have a complaint from federal court. And in paragraph 2.
Why do I need to take judicial notice of that?
So in paragraph 2 of the complaint for recovery, on this one, it says they checked the box, but there's no other pending or resolved civil action. They actually checked the box, and that's not true.
This is another pending action with the same people.
We have the same people, same thing.
Okay.
And I do have the sheet here if you'd like that.
No harm in having more than one lawsuit. So I'm not sure what the point of that would be. Mr. Tucker, you have some witnesses that you brought to court?
Actually, Your Honor, this is a summary proceeding action following foreclosure of the mortgage, and I am the attorney that did the foreclosure, so I will be the witness today.
So this is just a quiet title.
No, this is actually an eviction proceeding. It's under the Summary Proceedings Act.
Okay. Let me have you raise your right hand. Do you swear or affirm that the information that you're going to provide to the court will be the whole truth?
Yes, I do, Your Honor.
Lower your hand. So this is Choice One versus L&M Family Investment, but I don't see L&M Family Investments here.
That's correct. The Daltons, Mr. Dalton in particular, is the member of L&M Family Investments. But as we've already raised on the record and discussed with him at the preliminary hearing, he's not licensed to practice law in the state of Michigan and cannot represent L&M Family Limited Liability Company in this proceeding.
Well,
Now,
hold on. Mr. Dua's with us. Mr. Dua, are you here on this case?
No, Your Honor. I'm here on 2 other matters.
You're off the schedule. Consent judgments were filed.
Oh, we have consent judgments filed on those cases.
I didn't know if Your Honor wanted to put those on the record. So may myself and the defendant then leave?
Absolutely.
Thank you very much, Your Honor.
Ms. Kernahan's case was also dismissed. She's on Zoom.
Ms. Kernahan, your case was also dismissed. So you're free to leave. Okay?
Thank you, Judge.
All right. All right. So we're back with you, Mr. Tucker. You're representing yourself and
Choice One Bank.
go right ahead.
Thank you, Your Honor. My name is John Tucker. I'm attorney licensed to practice law in the state of Michigan. In that capacity, I'm familiar with the books and records of Choice One Bank as they pertain to the property at 305 West Elizabeth Street in Stockbridge, Michigan. Those records show that on November 20th of 2019, the defendant, L&M Family Investment LLC, took a loan in the amount of $196,000 from the Farmers State Bank of Munich. That loan was secured by a mortgage on the property at 305 West Elizabeth Street. Subsequent to the initiation of the loan, there's been a couple of bank mergers. Farmers State Bank of Munich was acquired by the State Bank of Fenton, who in turn was recently acquired by Choice One Bank. So Choice One Bank is the current lender with respect to that loan from 2019. The records further indicate that subsequent to the initiation of the loan, there was a default in the loan. And on April 24th, 25, the mortgage was foreclosed by advertisement. Choice One Bank was the successful bidder at that sale, and the bid amount was $178,598.52. There was a 6-month redemption period associated with that sale. That redemption period expired on October 24th, 2025, and Choice One was the successful bidder at that sale, and therefore, as a result of the expiration of the redemption period, Choice One Bank is now entitled to possession of the property.
Okay. So you don't have an attorney that's representing L&M Family?
I do not, Your Honor. But what I'm saying is that there's another case going on. I don't see how this case can go forward right now. With their specific documents, the box is checked that they're saying there's no other pending actions. There is a pending action. So for me, I don't feel like we can go ahead. I feel like we need to get through the other process first and then possibly come back here and do this.
This action was filed first, though, wasn't it?
That action was filed, his action was filed first, yes.
I don't think that limits his ability to go forward then.
Even if there's a separate case already.
Who knows what's going to happen with that other case? What judge do you have on that case?
Yeah, we have Judge Jarbu.
At the federal court?
Yes,
How is this a federal case?
because this has been our argument. We are federal land patent holders, and we are successors of the land patent, just like the original person. So this is a federal issue, is what we're thinking. We feel like this is a court of equity. We need to be in a court of law, Your Honor.
Well, this court is a court of both law and equity.
And we're asking if we can have this until we can hear our other hearing to postpone or.
Probably your best bet is to ask the federal judge if he would enjoin the practice of this court going forward. But at this juncture, there's no reason for me to do that.
You know, I'm saying here, just asking for my right to a court of law to be in a common law court. That's all I'm asking. And
That's what this is. So you should probably talk to your wife. It looks like she's furiously writing you notes, and you probably should see what she's talking about. Let me give you a minute to do that, okay? Ms. Hall, have you guys been able to work things out?
Yes, Your Honor, we did.
Are you going to send me a proposed order?
Yes, we agreed to a consent judgment. Would you like me to put the terms of that on the record?
No, I don't, because I'm actually a little bit backed up right now. But what I will do is I'll put a note in the file that you're going to be sending the post entry of judgment. I just want to talk to Mackenzie for just a second and make sure that you didn't threaten her or force her to agree to something. Is that right, Mackenzie?
Yes.
You have made any promises to her other than what she's going to indicate in the terms of the agreement?
No.
All right, then I'll just look forward to the agreement coming, okay?
Okay, thank you.
All right, I'll put a notation in the file that we are going to be expecting to receive a proposed order, okay?
Okay, and Ms. Thompson, you'll get a copy of that in the mail once it's signed by the court.
Okay, thank you.
All right, you have any questions of me before I let you go?
No, thank you so much. Thank you for working with me, you guys. Thank you. I appreciate it.
Hope it all works out for you, okay?
Thank you.
All right, you have a great day.
You too. Bye-bye.
Sir, I'm ready to hear from you. You have anything else that you'd like to say?
I'm sorry. Yes, Your Honor. We have in the Michigan Court of Appeals, they have said that Michigan has abrogated the common law of right to trial by jury. So I need to just we're asking that this is a court of equity. We want to be held in a court of law.
You to just calm down. I don't want you to have some sort of medical complication with each notice. Okay.
Yep.
I think I understand your argument. Mr. Tucker, you heard what he argued.
I did, Your Honor.
Would you like to?
Yeah, as the court has already indicated, the court is in fact a court of law. The court also has the powers under MCL 600.8302 to review and decide equitable issues within the context of the summary proceeding hearing. The base jurisdiction for the legal jurisdiction is MCL 657.04, which flatly states that this court has subject matter jurisdiction over summary proceeding actions, which you obviously know. You've been doing it all day long for a lot of years. So the notion that it is an equitable court is incorrect. This is a court of both law and equity, and the Michigan courts have been combined in law and equity since the Constitution of 1850 of the state of Michigan. So we're getting some very old ideological discussions that, for the most part, don't have any relevance to the current proceeding. With respect to the right to trial by jury, Mr. Dalton is mistaken, as the court knows, and as the Daltons probably know, because they were here on your first hearing where you read everybody their rights. And one of those rights is a right to a jury trial. And they have failed to exercise that right by not requesting a jury trial in a timely manner. So I do not believe there's any impediment to proceeding forward with the judgment of possession in favor of Choice One Bank.
Request for a judgment of possession for Choice One Bank is granted. If you prepare a proposed order, I'll sign it.
Thank you, Your Honor.
Anything else for the record?
Nothing from my end, Your Honor.
Anything else for the record?
Yeah, Just, I just want to say we have an allodial title and that has not even been discussed. We should be able to discuss that. We have the highest form of title. This is a matter of us.
L&M family. I don't know who you are as an individual, but L&M family is the defendant in this case.
But Michael Dalton holds the title to the property, the federal land patent, the highest form of title.
Well, you know, they missed that at my law school. They just concentrated on the state of the law in the state of Michigan at that time. So the judgment's going to be rendered in favor of the plaintiff in this matter. Mr. Tucker, if you'd get that order to me, I'll sign it.
Thank you, Your Honor. I'd be happy to do that.
And that's going to be all for the fixing. Okay.